Parole evidence rule. Section 10 evidence of written agreement. When the terms of an agreement have been reduced to writing, it is considered as containing all the terms agreed upon, and there can be, as between the parties and their successors in interest, no evidence of such terms other than the contents of the written agreement. However, a party may present evidence to modify, explain, or add to the terms of the written agreement if he or she puts in issuing a verified pleading. A. An intrinsic ambiguity, mistake, or imperfection in the written agreement. B. The failure of the written agreement to express the true intent and agreement of the parties thereto. Letter C. The validity of the written agreement. Or letter D. The existence of other terms agreed to by the parties or their successors in interest after the execution of the written agreement. The term agreement includes wills. 4. Interpretation of document. Section 11. Interpretation of a writing according to its legal meaning. The language of a writing is to be interpreted according to the legal meaning it bears in the place of its execution unless the parties intended otherwise. Section 12. Instrument construed so as to give effect to all provision in the construction of an instrument. Where there are several provision or particulars, such a construction is if impossible to be adopted as will give effect to all. Section 13. Interpretation according to intention, general and particular provision in the construction of an instrument. The intention of the parties is to be pursued, and when a general and a particular provision are inconsistent, the latter is paramount to the former. So a particular intent will control a general one that is inconsistent with it. Section 14. Interpretation according to circumstances. For the proper construction of an instrument, the circumstances under which it was made, including the situation of the subject thereof and of the parties to it, may be shown so that the judge may be placed in the position of those language he or she is to interpret. Section 15. Peculiar signification of terms. The terms of writing are presumed to have been used in their primary and general acceptation, but evidence is admissible to show that they have a local, technical, or otherwise peculiar signification and were so used and understood in the particular instance, in which case the agreement must be construed accordingly. Section 16. Written words. Control printed. When an instrument consists partly of written words and partly of a printed form, and the two are inconsistent, the former control the latter. Section 17. Expert and interpreters to be used in explaining certain writings when the characters in which an instrument is written are difficult to be deciphered, or the language is not understood by the court. The evidence of persons skilled in deciphering the characters who are understand the language is admissible to declare the character or the meaning of the language. Section 18. 2. Construction, which revert when the terms of an agreement have been intended in a different sense by the different parties to it. That sense is to rebel against either party in which he or she supposed other understood it, and when different construction of a provision are otherwise equally proper, that is to be taken which is the most favorable to the party and most favor the provision was made. Section 19. Construction in favor of natural light. When an instrument is equally susceptible of two interpretation, one in favor of natural right, and the other against it. The former is to be adopted. Section 20 interpretation according to usage. An instrument may be construed according to usage in order to determine its true character. See testimonial evidence, qualification of witnesses. Section 21 witnesses, their qualification. All person who can perceive and perceiving can make known their perception to other may be witnesses. Religious or political belief, interest in the outcome of the case or conviction of a crime unless otherwise provided by law should be not ground for disqualification. Section 21 Section 21 disqualification by reason of mental incapacity or immaturity. Section 22 testimony confined to personal knowledge. A witness can testify only to those facts which he or she knows of his or her personal knowledge, that is, which are derived from his or her own perception. Section 23 disqualification by reason of marriage. During their marriage, the husband or the wife cannot testify against the other without the consent of the affected spouse, except in civil case by one against the other, or in a criminal case for a crime committed by one against the other or the latter's direct descendants or ascendants. Section 24 disqualification by reason of privileged communication. The following person cannot testify as to matters learned in confidence in the following cases: the husband or the wife during or after the marriage cannot be examined without the consent of the others in confidence, the others as to any communication received in confidence by one from the other during the marriage, except in civil case by one against the other, or in a criminal case for a crime committed by one against the other or the latter's direct descendants or as ascendants. An attorney or person reasonably believed by the client to be licensed to engage in the practice of law cannot, without the consent of the client, be examined as to any communication made by the client to him or her, or his or her advice given their own in the course of or with a view to professional employment, nor can an attorney, secretary, stenographer, or clerk or other person assisting the attorney be examined without the consent of the client and his or her employer concerning any fact or knowledge of which has been acquired in such capacity, except in the following cases: furtherance of crime or fraud, if the services or advice of the lawyer were sued or obtained to enable or aid any to commit it or plan to commit what the client knew or reasonably shall have known to be crime or fraud. Claimants through same deceased client as to a communication relevant to an issue between parties who claim through the same deceased client, regardless of whether the claims are by testate or in testate or by the interverbose transaction. Breach of duty by lawyer or client as to a communication relevant to an issue of breach of duty by the lawyer to his or her client, or by the client to his or her lawyer. Document attested by the lawyer as to communication relevant to an issue concerning an attested document to which the lawyer is attesting witness, or job clients as to a communication relevant to a matter of common interest. Communication was made by any of them to a lawyer retained or consulted in common when offered in an action between any of the clients, unless they have expressly agreed otherwise. C. A physician, psychotherapist, or a person reasonably believed by the patient to be authorized to practice medicine or psychotherapy cannot in a civil case without the consent of the patient be examined as to any confidential communication made for the purpose of diagnosis or treatment of the patient's physical, mental, or emotional condition, including alcohol or drug addiction, between the patient and his or her physician or psychotherapist. This privilege also applies to persons, including members of the patient's family, who have participated in the